Good afternoon, good morning, and as I see we have some delegates tuning in from Asia, good evening. Thank you very much for tuning in to this live ICLG.com webinar. Just quickly, my name is James Strode, publisher of the International Comparative Legal Guide to Cybersecurity. We published our 2022 edition only a couple of weeks ago, and I would urge you all to download a complimentary copy through our platform today as some essential or go-to reading. It's great to welcome you all along to what's going to be a fascinating hour-long discussion with panel members from around the world as we discuss the hot topic within cybersecurity of ransomware. Before introducing the panel and getting to the crux of the webinar itself, I wanted to let you know that your input is most welcome today. We have a chat function to help you with that. If you have any questions or queries for the panel, please do type them in and we'll do our best to pick them up and discuss it. Approximately 37% of global organizations said they were a victim of some sort of ransomware attack in 2021. And the FBI's Internet Crime Complaint Center reported over 2,000 complaints from January to July this year. That's a 62% year-on-year increase. So the threat is very real, it's here, and it affects all industries. So today we're going to be discussing preparation, crisis management, and of course, the big question, is it lawful to pay the ransom? So without taking up any more of your time, I would like to introduce you to the contributing editor of the ICLG Cybersecurity and moderator for today, Nigel Parker. Nigel is head of Allen & Overy's Global Cybersecurity Group, advising clients on strategies for managing legal risk in relation to cybersecurity, including the deployment of a variety of risk management tools on the response to attacks and dealing with regulatory authorities. He also takes proactive steps in response to attacks, of course, including significant ransomware attacks. Nigel is recommended and recognized across Chambers and Legal 500. He's also named one of the top 40 under 40 data lawyers by Global Data Review. So Nigel, I hand over to you to introduce the rest of the panel and kick off the discussion. I'm very much looking forward to it. Thanks very much.
Thank you, James. Good morning, good afternoon, everyone. I am delighted today to be joined by two co-speakers. Ed McNicholas from Ropes and Gray. Ed is the co-leader of Ropes' data privacy and cybersecurity practice, and just to list a small number of his achievements, he's recognized by the National Law Journal as a cybersecurity and data privacy trailblazer. He's worked on some of the most significant data breach and data security events, SolarWinds, Yahoo, Equifax. He's editor and co-leader a co-author, of leading cybersecurity treatise, the cybersecurity, a practical guide to the law of cyber risk, and he's a lecturer on cybersecurity risk at George Washington University's School of Law. I'm also joined by Oliver from Swiss law firm Kellerholz Karad. Oliver advises clients on litigation and arbitration in commercial matters, as well as on internal investigations. He's got particular expertise across healthcare, life sciences, and more generally on data protection and information governance. Oliver was formerly a senior litigation counsel and head of global discovery and a global product lawyer at Novartis. We're going to structure the session today as a Q&A. I'm pleased to say we'll have absolutely no slides whatsoever. If you're looking for further detail on any of these topics, you can of course find them in your handy ICLG guide. Instead, what we're going to do today is work through a series of questions. We've got 10 questions we're going to try and get through, if time permits. We are from 3 different jurisdictions, Ed from the US, Oliver from Switzerland, myself from the UK. So we're going to try and draw out some of the differences across different jurisdictions. We are 3 lawyers, and so we're naturally going to focus on the legal aspects of this topic, the legal issues relating to ransomware and the role of the legal department in preparing for and responding to ransomware attacks. I think James has already perhaps adequately set the scene in terms of the rise of ransomware, but perhaps just briefly, Ransomware, of course, is a form of malware. It typically enters organizations through email, through some sort of phishing or similar email. Once infecting a system, it encrypts data and renders the files inaccessible and unusable. Typically, attackers will have also extracted data before encrypting files. Attackers will then demand a ransom in return for the release of decryption keys to restore access, and they may threaten to release data if a ransom is not paid, as a form of double extortion. And amidst the pandemic, we've seen a surge in ransomware attacks across the globe, with estimated costs hitting $20 billion in 2021. And there's been a surge in claims and cyber insurance policies relating to ransomware attacks. Attackers have been taking advantage of vulnerabilities created by the pandemic, the switch to increased home working and the correspondent adoption of new technologies and working practices. And ransomware attacks have become increasingly lucrative and seemingly easier to carry out, as we now see groups offering so-called ransomware as a service. We've seen numerous high-profile attacks. So, to our first question, and perhaps the one that's most frequently asked or first asked of lawyers, is it lawful to pay a ransom if you're the victim of a ransomware attack? Ed, would you like to kick us off?
Well, of course, I would be inclined to say, well, it depends, because I'm a lawyer. But let me resist that temptation and say, generally, yes. And at least in the US, I'm not aware that any company has ever been pursued for actually paying a ransom. There are some concerns in the US about whether or not, if you make a payment to a specially designated entity that would be on the OFAC or trade sanctions list, you could find yourself in hot water. Although that is a in the U.S. it's a strict liability offense, and so even if you exercise some level of diligence, if you still wind up paying a ransom to, I don't know, Al Qaeda or something like this, then you could potentially be exposed to a regulatory proceeding from OFAC. That being said, they've issued guidance noting this possibility, somewhat trying to deter the payment of ransoms, but they've never actually brought it. And so one of the things that's been happening in the US recently is some of the ransomware attackers have been trying to get to a new level of hell and been hitting hospitals in the middle of the pandemic. And so if I'm dealing with a hospital who's gotten locked up and they have patients at risk, I say the potential exposure from having someone suffer an adverse health event from this ransomware is so much greater than anything that would happen from paying this ransom. You should pay the ransom and get your systems back up if they're vital for patient care. So there is some nuance to it, but generally, yes, in the US, you can pay it.
And how about you, Oliver? Is it the same in Switzerland, or are there any differences?
Really very much like what Ed has just told us for the US. Generally, yes, it is lawful to pay a ransom. There is in Switzerland the National Cybersecurity Center, which is the Swiss Confederation's competence center for cybersecurity. They're not a regulatory authority, but they're sort of the first point of contact for businesses and the general public for cyber issues. And they very much like what we've heard from Ed, they recommend not to pay ransom payments, but it is really just like what we've heard, really a balancing exercise. Same as we've heard before, don't just jump into ransom payments. There are a few legal questions to be asked, including, of course, sort of OFAC style payment bans to certain foreign destinies. Things like that do exist in Switzerland as well. And then there is sort of a peculiarity, I would almost say, of the Swiss Swiss law when it comes to cybersecurity, Switzerland doesn't really regulate cybersecurity in a comprehensive manner, but it regulates cybersecurity really very much with respect to specific objects, be that sort of data systems or products on the one hand, and with respect to specific industries. And when you are in one of these sort of high risk, crucial industries in Switzerland, and that certainly includes banking, finance, so banks and insurance companies, healthcare, telecommunications as well, then you do have, and we're going to talk about this more, I guess, during the discussion here, but you do have information obligations. So the authorities will expect that you actually enter into a discussion with them about ransom payments. And so does actually usually the police in Switzerland. So there is a bit of a sort of communication culture around ransom payments, but as Ed has said, no general ban on ransom payments in Switzerland either.
Yeah, and I'd say it's basically the same position in the UK. Generally not unlawful, but there is this risk of infringing terrorism financing legislation or financial sanctions. I guess one interesting sort of thought is that the reality is you often don't know with any certainty who the attackers are. You may have an idea if you've got some forensic teams in. They may be able to sort of indicate who they think the group is, or the group may identify itself. Some of them are sort of quite well known and actually rely on their sort of reputation, but you won't necessarily know who the specific individuals are behind it, which means that you often find yourself I guess able to get comfortable with that risk on the basis almost of that lack of certainty that you are not in a position of knowing that you are or being sort of sufficiently reckless that you are committing an offence. But I guess you touched on it, Oliver, sort of the fact that possibly the answer to this question might be different depending on the sector that a business operates in, and obviously financial services particularly sort of sensitive and important sector in Switzerland. Do you think the answer to that question is different if you're, say, operating in the financial services sector?
No, not generally. There as well, the principal answer is that there is no general ban on ransom payments. The fact is just, as I've said, that there are very strict reporting obligations in the financial sector, in the medical sector, as well as in the telecom sector, that are actually sanctioned with rather hefty fines. So for example, if you are a supervised person or entity in the financial sector, and those are banks and insurance companies usually, then you have to report incidents that are of a substantial importance to the supervision by the Financial Market Supervisory Authority, FINMA. And if you don't do that, you can incur fines up to 250,000 Swiss francs. So rather sort of strict supervisory obligations that could then furthermore sort of, if violated, lead to a revocation of the license, or a withdrawal of the recognition or cancellation of registration. So these authorities, they do expect that you notify them, and they do expect to have a say in that balancing exercise that I had described before. So it is not wise to sort of try to stay under the radar if you're in one of these critical industries. Very much sort of similar in the healthcare sector. That has become, and Ed mentioned hospitals, so that is, in Switzerland, that has become one of the hot issues now with the introduction of the electronic patient record. And there's sort of a Swiss-wide electronic patient record, at least sort of a legal basis for it. We're sort of struggling with the implementation a little bit. And they're rather strict notification obligation there as well in terms of data breaches in connection with a cyber attack. and similar sort of in the telecommunications sector. So the answer is, I think, for the special industries, the same as in general, but with heightened diligence and notification obligations impending on the respective companies.
And Ed, how about in the US?
Well, in the US, we've got a complicated approach to cybersecurity, to say the least. As opposed to having something that is omnibus, we have each sector approach cybersecurity in its own way, and then we have overlapping state and federal provisions on it. And so when American clients complain about, oh, this European law is so complicated, it's so diverse, I'm like, guys, we have 50 states here and federal, and we do it by sector, not to mention common law issues. And so the reality is that in the US, you will have the reporting requirements for ransomware itself are rather thin, unless we fall into a couple of buckets. One of the major regulators of cybersecurity would be the Securities Exchange Commission. If the payment is material to a public company, it has to be disclosed to investors on an 8K. Also, if you are otherwise regulated by the SEC, such as you're an investment advisor or a broker dealer or such, the SEC will expect to be notified, as with other prudential financial regulators, of any significant cyber attack. That being said, in the US, we've not had a specific requirement to report ransomware payments to one centralized area. And so there's active debate on Capitol Hill about whether or not we should have a law requiring ransomware payments be reported within maybe 24 hours after payment to CISA, which is part of the Department of Homeland Security, a somewhat new agency that is stood up that's trying not to be a regulatory agency, but trying more to be an information sharing agency. Where the rubber hits the road in the US is where you have the personal data breach notification. The first wave of ransomware simply locked up data. The second wave tends to take a copy of the information and use it for this double extortion, starting with the ryuk, which apparently is a Russian word for hands, but my Russian is horrible, so forgive me if you speak Russian. But it is they would take a copy of the data, and that may well constitute a breach of personal data, which falls under the regime of 54 different state and territorial data breach notification laws, as well as notification laws in different sectors. And so it is particularly for a multi-sector company, it can be quite challenging, because if you are, let's say, if you were a company like the old GE before they started spinning themselves off, you might have nuclear regulators, electrical utility regulators, consumer regulators, financial regulators, healthcare regulators, all from the same company. And so if you had an attack at the headquarters of the old GE, boy, you could spend a long time making regulatory notifications. The other piece of that is the OFAC piece that I want to mention. If you have to do a payment, you'd want to document your due diligence in trying to make sure that you at least check the list, so that you're not knowingly sending something to an account that's been used by terrorists. Now, normally the ransomware payments, they keep moving their accounts around so quickly that the account that you've been given is usually not associated with a known threat actor, and you don't really know who you're making payment to. But it's always good to document at the time of the payment that you do not know, that you have checked, and after the exercise of due diligence are not aware that you are making payment to a known designated entity on a watch list or terrorism list. So even if it turns out you did make a payment that unfortunately went to support international terrorism, you can say that at the time you did not know, and after exercise of diligence, and that will probably go a long way with regulators and making sure that they don't take a dim view. There is also the FBI actively encourages companies to report. There's no requirement to report to the FBI or any other law enforcement, but the FBI has sometimes will have the keys to the ransomware. And so if the FBI has hacked the ransomware attackers, they may well be able to give you the keys for free quickly, which makes the prospect of reporting quite interesting to them. Although they did have an incident recently where they had the keys and chose not to give it to corporate customers because they were in the middle of taking down the ransomware gang and did not want to expose to the ransomware gang that they had hacked them. So you have to remember that their ultimate motivation is to go after the bad guys, and as opposed to help corporate victims.
Sure. I want to come back to this sort of question as to whether it sort of is a good idea or not to involve law enforcement authorities outside of where it's required. But I guess just an additional thought about, kind of how this question about whether you may be able to pay a ransom or not, and how that question may be different in a regulated sector. If financial services, for example, organizations are required, not just in the UK, but in other countries, to have sort of adequate systems and controls in place. And that's not just adequate systems and controls to prevent ransomware attacks occurring in the first place, which will obviously come under scrutiny if you have to report that you're the victim of an attack to the regulator, but you've also got to have systems and controls in place to prevent financial crime. And so, very much like checking the OFAC list, there's an obligation on financial services organizations before they pay a ransom to be taking the right steps to make sure they're carrying out the appropriate checks to the extent possible to make sure that they're not breaching these pieces of legislation we mentioned earlier around sanctions and terrorist financing and so on. But returning to this question about sort of whether it is a good idea or not to involve law enforcement authorities as opposed to regulators, is that a sort of dilemma you see your clients sort of facing, Ed? And kind of how does that usually pan out in terms of whether they will involve law enforcement or not when they're subject to a ransomware attack?
There is some hesitancy because if you pick up the phone and or send an email to the FBI to ask for their assistance, one, there's making sure you actually get the assistance. The rate of ransomware expansion has been so great that even companies that immediately notify the FBI, if they just send it in to the general internet crimes email center, they have an email you send it to, or you can call the internet crimes center. You might get a response back in 2 or 3 days, which is a long time in ransomware. And so companies will say, well, this is not useful to do this. One of the things that can be done is companies have taken the time to get to know their local FBI agent. And their FBI has agents in most major cities. And so if you know someone local, they can help considerably to facilitate getting you to the front of the queue so that you actually get response in the right time. And that can be critical in terms of the ability to potentially claw back payments or to get keys or have helpful guidance in that way. Calling the FBI does tend to put you in an awkward situation if you determine that you don't want to disclose this to your regulator. So if you're going to try to keep it as quiet as possible, then bringing in law enforcement is probably not a good idea, because law enforcement will eventually ask, by the way, did you mention this to your regulator? And they won't, if you say no, they'll say, well, we encourage you to do that. I've not seen the FBI then pick up the phone and call the regulator and say, we're concerned they haven't complied, because I think the FBI wants to keep the culture of their investigation confidential. And there are some good reasons under the federal rules of criminal procedure in the US for them to do that, because they're often doing it in the context of a grand jury investigation. That being said, companies generally have the sense of, once you bring in the FBI, once you bring in law enforcement, you are then bringing in everyone else that goes with that. And you're putting yourself down the road towards public disclosure of the incident, whether you like it or not.
And Oliver, what about in Switzerland? Is there a concern about regulators talking to law enforcement talking to regulators? Is there kind of an assumption that if you go to the law enforcement authorities that it's going to, mean involving applicable regulators as well?
Yeah, that there is I think exactly sort of this triangle that I described, that I would say sort of what is it that you actually want or hope for from the authorities? How much control? Second, how much control do you want to keep? And then sort of third, how sensitive is this in a way? So depending on sort of which organization you are and what data is involved, sort of how much control do you actually need to be keeping because of the sensitivity of the matter. There is the concern that if you involve law enforcement, that this becomes that you will have less control, and this becomes trickier. The situation in Switzerland is maybe a little bit different from what we see here in the US, in that the law enforcement authorities are essentially sort of the either sort of the police departments or the federal or local public prosecutors. And while there are sort of nowadays, or have become sort of, well, some of them, at least on federal level, have become experts, and can really be helpful at times, especially when it comes to prosecuting attackers or clawbacks of money, etc. In the first stage of an attack, when it comes to sort of technical questions, there the first step will rather be to approach the National Cybersecurity Center in Switzerland. And that is a federal body. That's the one I mentioned earlier. That's a federal body which has a very clear sort of technical focus. And they have a lot of guidance already on their website, and there is sort of a direct link on their website where you can report an incident. And they will actually analyze this very quickly and get back to you with guidance. So there is the possibility that you can actually sort of collaborate with the experts from the NCSC. And they're really on at the top of their game. And they will actually sort of help you on the technical side without regulatory involvement. So the first port of call, if you're looking for external sort of government support, will be the NCSC in Switzerland. And then of course there are a few, or at least sort of one other sort of body that I'd like to mention, which is CYCO, the Cybercrime Coordination Unit in Switzerland. So if that is a unit that's located at the Federal Office of Police, and they're sort of less there to support you, but they are actually sort of the body, the central office that pursues or prosecutes illegal activities on the internet, sort of in the framework of the Budapest Convention on Cybercrime, etc. So if you want sort of law enforcement to go in hard on crimes on the internet, there is a possibility to notify CYCO. That is not something then that will help you, but they will then sort of go out and deal with that on their own.
Yeah. Yeah, so it's a similar position in the UK. We have a national cybersecurity centre as well, and they make it sort of very easy to notify them of the instance via their website, and will provide, quick responses, assistance, and support. They are explicit that they will share information with law enforcement partners like the National Crime Agency if it's appropriate. It's also recommended in the UK that you notify the police action fraud, which is part of the UK police. Whenever you're subject to a ransomware attack. Part of it really is just about being a good corporate citizen and sharing the information in the first place, because it's really vital for authorities to know kind of what's going on and so on, in order to be able to kind of fulfill their role, their sort of protective function. If organizations aren't sharing this information, it really limits their ability to do that. We've touched on it a bit already.
Nigel,
yeah.
Sorry to interrupt. I mean, if I may just ask, add one more point. At least in Switzerland, going forward with the new Data Privacy Act in Switzerland that will come into force, sort of 2023, we think nowadays. You will have an obligation actually to report severe incidents or breaches of personal information to the Federal Data Protection and Information Commissioner. And that is one of the ways that, or one of the sort of opening doors where you actually almost certainly can't avoid notifying the federal authorities in the future. Not yet the case, but that will certainly be the case in the future.
Yeah. And that's certainly the case already in any sort of GDPR country, or in the UK as well, UK GDPR. Most ransomware attacks will give rise to an obligation to report to the ICO, because either the attackers will have gained access to information, will have exfiltrated information that includes personal data, or they'll have locked up the personal data, and the mere lack of availability to personal data, unless it's sort of unlikely to give rise to any risk to individuals, is itself a data breach as well, and so would be reportable. So we do find most instances that we get involved in, we're reporting to the ICO. For certain companies that are subject to the Network and Information Systems regulations that derive from the European directive, sort of same story. If you're an operator of essential services or a digital service provider and you're subject to an incident, it's likely going to be reportable. And if you're in a regulated sector, there's going to be possibly an obligation to report to the financial services regulator as well. Ed, what about sort of mandatory reporting obligations in the US in relation to personal data breaches? What's the, is it likely that a ransomware attack is going to be reportable across these sort of multiple different states in the US?
It really goes to the nature of the ransomware. And that's one of the things that's very helpful to get a good forensics provider in, or to one of the things that the FBI can help with is identifying the threat actor. Because the nature of the ransomware, the nature of the threat actor, some are known to just lock up systems. Some have known to lock up systems and take a copy and then use it for extortion. And some are known just to take a copy and not deploy ransomware. We've now seen that variant as well, just a straight out extortion attack. And that issue about whether or not you have to report usually goes to whether there's been unauthorized access to or acquisition of information. There is a good debate in the US about, if you pay the ransom, does this somehow eliminate the risk of harm? I think most regulators in the US would say that no, there's still been unauthorized access to the information. Even if they gave it back, it was still in the hands of criminals for some amount of time, and this is problematic and needs to be reported. Others have said, no, we need to incentivize payment. And so some defense counsel have taken the view that no, if you pay the ransom and you get the attackers promise to not use the data, and they promise they've given it back to you, you can rely upon them. Although I don't generally side with the regulators, I think the regulators might have the better side of this debate, that we can't trust ransomware gangs. We can't kind of take their word for it. that they've not kept a copy and aren't doing anything bad with it. And
we're
so
often asked that question as well, Ed, this sort of
Yeah.
question about whether, you know, is actually for the information regulator who's there to kind of protect information, is actually a good story to tell them, to say, hey, we paid the ransom, we got the data back, they, you know, so actually we've, by paying the ransom, reduced the risk to individuals, and so that's a good thing. Do you think regulators don't sort of quite buy that narrative, or is that, does it, you know, is there a positive side to it?
It helps. In the US, the main problem will be from the lack of controls that allowed the information, the malware, to be deployed in the first place. If you, say, for instance, don't have multi-factor authentication on your systems, and had poorly trained employees who, you know, there was a phish that hit your company, 10 people clicked on it, and the attacker was able to jump right in because all they needed was a username and password. They're not the fine and regulatory scrutiny will not come because someone placed malware. It will come because you didn't have enough protections in the first place. And whether or not you pay the ransom doesn't do anything to ameliorate the fact that you weren't paying attention enough to this to have multi-factor authentication on. To my mind, that's going to be the long pole in the tent for the regulators' cases. They just point to a lack of multi-factor authentication, and if it's not there, or there is no record of training employees on these issues, no use of Mimecast or other technologies like that to filter out obvious phish. These things go, you know, I think the regulators go towards a negligence in the protection of information, as opposed to focusing on malware itself.
Yeah. And where incidents are reported, you know, if you're kind of advising a client that they have an obligation to report, how do you kind of manage their expectations as to kind of what happens next? Like, what are the kind of, other than sort of things like multi-factor authentication and so on, what are the kind of red flags that you think are going to pique a regulator's interest and going to perhaps single out a particular ransomware attack for further sort of investigation and action?
Yeah, I had a chance to do a discussion with one of the guys from the New York AG's office, who actually is the guy who sorts through the notices that come in, and it's probably a useful thought experiment to put yourself sitting in his desk, where you're getting maybe 25, 30 notices a day. You can probably pick one a week to really pursue. Maybe you can send a couple inquiry letters, but if you're really going to pursue something, you're kind of picking one. And how do you pick that one to go after? And some of the things are, one, that this attack never should have happened. It was something that should have been prevented. Two, it involves a lot of people. Numbers matter usually for the larger jurisdictions. If you don't get over at least 25 or 50,000 people impacted, it's just not going to be worth the effort of the regulators to go after it. And then three, if you sit on it for a good amount of time before telling the data subjects and the regulators about it, that will earn you a special bit of attention from them. I've had clients who sat on notifications for a couple of years before getting around to deciding it, and maybe we should have reported this. And when the regulator does a stop and looks at the dates, it's, wait, that was 2 years ago. That will get their attention. They want to know why it took so long.
Oliver, any additional thoughts?
Yeah, if I may just add one thought, sort of the as I'm sure you would agree, sort of the event sort of doesn't usually sort of, it comes suddenly, but it is more sort of a slide, right? Where you get more and more into the area where you have to disclose information. So you very quickly, depending on which systems are affected, come into questions of notifying your business partners of notifying your insurers, notifying if your data processors, notifying data controllers, etc. Right, and if you're a publicly listed company, right, you're going to have to certainly avoid selective disclosure issues. If you're not, you will have to anyway also be very careful so that you're not sort of just telling all your business partners, but not the relevant authorities. So there is a degree, and I think Ed has beautifully sort of sketched that out. There is a degree of consistency of behavior there that is important from a regulatory side, and then I'm sure we're going to speak a little bit about public communications as well. That is crucial when it comes to communicating to the public about how you're handling an attack.
Yeah. You mentioned insurers, Oliver. What about the kind of communication with insurers when you're subject to a ransomware attack? What does a company need to do there if it's, say, taking out a cyber security insurance policy? What does it need to be mindful of in terms of how it then responds when it's subject to an attack?
Well, the first thing is to pull it out of the drawer and read the terms, which is more often than not simply not done. Many of these insurance policies have clauses where in order to secure your coverage, you're going to have to get agreement from the insurers. So you certainly, and there's not much time. I think, Nigel, you alluded to this before, right? This is more just a question of days usually than of weeks. So you have to, under these policies, usually sort of very quickly notify them and get them on board as to your strategy, including, and that's something Ed mentioned before, getting them in contact with your cybersecurity experts and having sort of explained to them, for example, where a ransom payment goes to, because what I have seen happening in some cases in the market is that insurers raise concerns about a potential facilitation of breaches of OFAC regulations, for example, if they just give you carte blanche to pay anything.
One of the if an instance sort of occurs and becomes public, and perhaps we can sort of come on to sort of talk about the best way to kind of handle communications to the public, to customers, to employees and so on about an incident. But when something like a ransomware attack occurs, there's often a certain sort of pressure to give reassurance, isn't there, to perhaps individuals or organizations that might be worried about what the incident means for them. Maybe they're worried about interruption of services because systems have been locked up. Maybe they're worried about the integrity of their data, protection of their data. All of these things create a lot of pressure on an organization subject to an attack to give assurances. Do you think that's a good thing for an organization to do, to start making sort of promises and say, don't worry, we'll put it all right. If you suffer any harm, we'll make it good. How does an organization kind of weigh up the right thing to do there, doing the right thing versus obviously sort of protecting the organization? Ed, Oliver, either of you, any thoughts?
Sure, I will jump in. One thing that in the U.S. got everyone's attention was actually involving a Pearson, which is a London company, but they suffered a cyber attack, and when they announced it, they issued out a statement that was, to my experience, not exceptional, but the SEC took them to task and said that they were misleading. And it was interesting that they said they were misleading because they said, and I'll quote just because it was shocking, it said, protecting our customers' information is of critical importance to us. We have strict data protections in place and have reviewed the incident, found and fixed the vulnerability, end quote. Now, people say stuff like this all the time, that this is, your personal privacy is very important to us. We're very sorry this happened. And the SEC seemed to be going after them by saying, well, it really isn't your top priority, is it? Is it because and are you positively sure that you fixed everything? And that kind of PR speak for that to be deemed misleading, and then the SEC suggested it was not only misleading but material because of the nature of the business, not because of the financial impact. On a financial basis, the Pearson breach was not significant financially, but they said, well, Pearson is a large educational publisher, and this involved student records, and so it would be material to their reputation, even if there's not a short-term financial impact. And I think that has gotten the attorneys to be much more aggressive in making sure that the PR folks do not put too much happy talk, as I call it, into the messaging here, just to be very straightforward about what happened. I do think that companies can do themselves a ton of good if they will coordinate with the insurance companies up front, with their regulators, and go out publicly all at once, so that if they catch a news cycle, they catch one bad news cycle, and they don't kind of sprinkle it across several days. I think that the communications and prompt communication is vital. People at this point strike me as consumers and investors, even regulators, will forgive getting hit by ransomware, but they won't forgive the sense that companies lied to them or were sharp in their disclosure about the ransomware, because that they see as more intentional than being just hit by ransomware.
Yeah, yeah. I wonder if often the sort of the reason some of this PR speak creeps into these communications is often actually the kind of lack of information that an organization has, and perhaps the uncertainty and stress they're under, kind of the pressure to say something kind of leads to sometimes saying these kind of quite bland things that don't really say anything, or which kind of give false assurance. But I think you're advocating, Ed, aren't you, being to the point, direct, factual, timely, all these things. There's no denying that it's sort of challenging to achieve that, isn't it?
Oh, sure. There's tremendous fog of war, as it were. We've had situations where a global company was hit, and it went across thousands of servers. And then you ask the company, what's on the servers? I said, well, we were planning to get around to that data mapping project, but we didn't quite get it done. So we're really not too sure what's on these servers, but we could ask. Well, there's several thousand servers involved. Don't you need to ask right now? And so you wind up sending an army of associates out to conduct a heck of a lot of interviews to figure out what was on these servers. And not having that information pulled together in advance, not having the records of processing in hand, so what information is sitting on which servers, and what can be hit by an attack, is very problematic. And that those chickens will come home to roost, as we say in the US, when you get hit by ransomware. That if you don't know where your data is and don't really know what personal data or sensitive data you have, then it will be very hard to come out with one consistent message. And you might wind up sending multiple messages over multiple days, which the press will just love, because they can talk about the expanding breach at this company. Yeah.
Yeah. What are your thoughts, Oliver, about the best way to handle comms? Yeah.
I couldn't agree more. For sort of years of in-house experience, I would sort of even try to boil it down into two rather unpopular messages. One is stay silent until you really know what's going on, and say it all at once, as you put it, Ed. And don't communicate piecemeal. Don't do PR clean washing. Don't do any of these things. And the other one is, I think, and that's a rather unpopular message to communicate to your communications friends in-house as well, and that is, I think a good communication strategy, more often than not, is based on a good legal strategy. So unless you have sort of a pretty clear idea what your legal strategy is going to be, going out to communicate is always a risky business. So I would advocate for clients to have their legal and communications departments work very closely together in these instances, and also have external counsel, frankly, sort of work closely with the communications experts if this is not done in-house.
Yeah.
One
Well, that
of
brings
the-
us. Sorry, Ed, go.
I was just going to say, one of the other player that looms so large is the insurance company, because they were ultimately the ones who will be paying the ransom if the payment is to be made, and so they have a seat at the table and making sure, one, you're not dealing with there's a problem of what they call silent cyber, where people try to make claims for ransomware payments under general policies, suggesting that the failure to exclude cyber means it's included. People thought silent cyber was going away, although just recently there was an Ohio Court of Appeals case that recognized silent cyber coverage. And so there's people still make those claims, and it's still out there. And at the same time, you have to recognize that the insurance companies have gotten hit very hard by this wave of ransomware, and are their profit, the way they set their premiums did not anticipate this ramp, and they have just gotten pounded on ransomware payments, and so they are very sensitive about it. And I think AXA in France actually has stopped writing ransomware, and you could see other companies taking a similar bent of saying, "We're just getting out of the biz. We're not going to be paying ransoms, or we're going to be very hesitant to just pay what's asked. We're going to negotiate them down." And the way you negotiate down is you wait several days, which from the insurance company makes an awful lot of sense. The PR company, your PR and your customer relations and operations people are not very happy about that, though.
Mm-hmm. It's good, of course, to have thought about all of these things in advance. Oliver, you sort of referred to it as sort of thinking about what your kind of legal strategy is, and I guess understanding the sort of relationship with the insurer and kind of how they're likely to react, and sort of thinking through that in advance. What other things I guess can the legal department, can the legal advisor do to help prepare the organization for a ransomware attack? What are the kind of things that would be at the top of your list, where kind of legal can add value in helping reduce the risk?
Well, I think legal can, on the one hand, really give input, and on the other hand, can be a really good facilitator. In my experience, it is very often the legal department that is driving some of these preparatory work. I would highlight 4 points, and I wonder whether you would agree from your perspectives. One is really do your homework in terms of data privacy, in terms of privacy by design and default. I think the more you sort of do your homework on the technical and organizational side, in terms of privacy by design, and the more you actually implement the principle of data minimization, the better you are prepared, at least on the personal information side, when an attack happens. And then we've talked about an incident response plan. That is sort of the second point I would highlight. And that, I think that means that I think you should take stock of what are your assets, and what are your types of potential incidents that you might face. What are your stakeholders, internal and external, so that you know whom to address when it happens. And what are the roles and responsibilities? Surprisingly often that's far from clear when an incident happens. And when you start talking about who should be responsible in such a situation, that's rather not good. We've talked about communication plans, and then I would probably sort of in a legal in-house department also sit down together with the guys handling the business continuity plan and really sort of check how an incident response plan weaves into the business continuity plan. So that's the sort of 4 parts, sorry, that I would highlight in terms of preparatory work. I'm sure there is more, and I'm curious to hear your thoughts.
Ed?
Sure. I would throw in the, particularly in some sectors, having this reduced to writing is crucial. But certainly agree with all your points. The other point is the absolute necessity of doing tabletop exercises involving the senior decision makers. Having the IT guys run tabletops in which they walk through various scenarios is crucial. They have to be able to know how to respond in a crisis. But in any number of circumstances, I've seen companies have ransomware attacks, and they will have a meeting of the executives, and the executives, each of the product heads and legal and marketing and finance, will say, yes, I'm in charge of this. And then they realize they have 6 or 7 people in charge of it, each of whom might have their own incident response plan. And then it's tossed to the CEO, who might never have been involved in any of the incident response planning, who then has a discussion with the chair of the audit committee, who might not have thought about this in advance. So making sure that the incident response planning goes all the way up, and there's that hard discussion that gets this onto the agenda of the senior executives, I think it is crucial.
I agree. I mean, one of the privileges we have as external counsel, I guess, is we're often sort of drawn into clients' instant response teams when something happens, and you can really tell the difference between the organizations that have practiced it and those that perhaps haven't so much. Or to be fair, there's a real difference between the organizations that have had real life incidents, in numbers in the past, and they've actually had to kind of live it in reality and have kind of ironed out the issues with their response plan and implementation of it. But certainly everyone in the team kind of knowing their role, and it being sort of properly coordinated, it makes such a difference. And having the sort of regular reporting up to the executives, involving the different teams, PR, for comms, HR, etc., etc. So the right people are there in the room and helping make these decisions quickly in real time. But I think I was just going to say, sorry, thinking more broadly what the legal team can do about ransomware. Well, one of the things that's really recommended is to keep backups of data, and obviously, keeping backups of data often will involve third parties having contractual obligations to keep backups of data. So, there's this role of the legal advisor much earlier on to make sure policies and so on are getting reflected in contractual arrangements. And obviously, another way of protecting against attacks is deploying all of these tools, like monitoring tools over networks, running simulations like phishing simulations, penetration testing, and so on. And all of those things kind of need legal advice to implement them. And so the legal advisor, as a facilitator of helping the organization to deploy these tools, these techniques, is sort of a key way of mitigating the risk.
Having the relationship with a forensic vendor is also important.
Yeah.
So you're not dialing around trying to see if someone will come and look at your systems in the middle of an attack.
Yeah, absolutely. Having all those contracts in place and not be scrabbling around to document them in a panic.
And there's a governance side to this as well, right? I mean, an incident governance. Lawyers are rather good often at sort of ensuring governance, meaning sort of that incident response plans are properly followed, that you actually document what you're doing in such a situation, that you preserve legal privilege where necessary. I don't want to open up an entirely new landscape here, but all of this governance is something that can be where lawyers or the legal department can actually add value.
Absolutely. Okay, well, I am conscious we are almost at the top of the hour, so I think we'll have to call it to a close there. Ed, Oliver, thank you so much. I really, really enjoyed the discussion. And I think James may want to wrap up with a few final words. James.
Yeah, thank you very much, Nigel, and of course to Ed and Oliver as well for your insights. I mean, it's gone extremely quickly, that hour, and it's moved across industries, across authorities, across laws, and so on. I mean, really interesting, and I'm sure many more questions to ask. But all that there is really for me to say is, If anybody does have any further questions or queries or would like to continue the discussion, you're more than welcome to hang around, and there's a networking tab on the left-hand side of your screen to enjoy further discussion and chat further. But if you've got to dash off, no problem at all. It's been fantastic to have you with us today. Don't forget, you can pick up and download your ICLG cybersecurity publication on the homepage. And again, just thank you to the 3 panel members. Thank you for you guys for tuning in. And perhaps it's a bit too early to say Merry Christmas and Happy New Year, but we're into December now. So all the very best and hope to see you soon.
Thanks, James. Thanks, everyone.